This is Todd Peterson. I'm an attorney at Bassey, Edlin, Hewley & Bloom in San Francisco. We also have an office in Los Angeles. This is a presentation of contractual elements of maintenance contracts. My business as a lawyer, my practice as a lawyer, is to represent construction companies, in particular companies that rent or manufacture or somehow provide big pieces of construction equipment to the construction industry. In particular, I represent rental houses that will rent pieces of equipment such as bulldozers or forklifts or boom lifts or scissor lifts to people, to the general public, for use on construction sites and other places. One of the most difficult parts in that industry is the paperwork, getting the paperwork correct, getting all the things in the contract, getting everybody to like the contract, everybody to agree to the contract, getting everybody to sign the contract. This is difficult not only because it's just difficult, it's hard to do, but also because the people in the industry, this is usually not their favorite part of the job. Their job is to go out and sell rentals, provide rentals, deliver rentals, and run the business. Contracts are considered something complicated, but in fact, the business world turns on whether or not you've got your paperwork correct. This very brief seminar does not include elements in regards to all types of contracts or all types of situations where contracts might come into play. Instead, it deals with two very simple things to explain in the beginning, but those things get to be extremely complicated as they go along. What we're going to call these are red flags in the construction contracts, and in particular, the things to watch for when signing a contract are clauses for indemnification and clauses for insurance. Starting out with indemnification. Indemnification provides indemnity. Indemnity is something that should be pretty simple. Indemnity simply is the obligation of one party to make another party whole. If something goes wrong to one party is damaged, the other party agrees to make them whole, to pay for that damage. That doesn't sound terribly difficult, but in practice, it's enormously difficult. These indemnification clauses are often included in rental contracts, sales contracts, maintenance contracts. They often require party one, that might be you, to be responsible for the negligence of party one. In other words, when you would be responsible for your own negligence. Or it might also require you to be responsible for the negligence of your customer, of party two. Or even it might require you to be responsible for the negligence of party three, even though you don't know who that party is, you've never met that party before, but if you signed the wrong indemnification clause, you might be obligating yourself to be responsible for that third party's negligence, perhaps your customer's negligence, and perhaps your own negligence on top of that. To be valid, any indemnification clause must be clear and unambiguous. It must result from an arm's length transaction. It must not violate any special state laws. Let's back up for a minute. The clause must be clear and unambiguous. I'm a lawyer. If I'm writing a clause that's clear and unambiguous, folks, I'm not doing my job. We lawyers cannot help but make clauses complicated and difficult to read. This puts us in a really deep hole because this can be a very complicated area, and making a very complicated situation be reduced to a clear and unambiguous clause in a contract is difficult. If you are relying on that clause to provide you with indemnification, to provide you with the right to be made whole in case something goes wrong, keep in mind that that clause has got to be clear and unambiguous. That's hard to do. Also, the clause must result from an arm's length transaction. In other words, two adult parties negotiating the transaction. It can't be the result of arm twisting. It can't be the result of favoritism or anything of that nature. It's got to be a straightforward arm's length transaction. And it can't violate any special state laws. In a minute, we're going to tell you what some of those laws are. Indemnification clauses. There are enormous differences in laws from state to state. This is an incredibly complicated area. In the United States, we have 51 separate jurisdictions. That's 50 states and the District of Columbia. Each one has case law that may or may not be different from that in other states. Let me give you an example. In many states, in construction contracts, and that's a loaded term, construction contracts, and each statute will define what a construction contract is. If you are in the rental industry, per these definitions, these statutes apply to you. In some states, in construction contracts, they will bar one party from being responsible for the negligence of another party. For example, in California, if you have what we call a Type 1 contract, that is a contract where you agree to indemnify your customer even when the customer is solely at fault and you are blameless. You did nothing wrong, but the contract still says that you're going to be responsible for your customer's screw-ups. In California, those are barred in construction contracts. Now, that's an important thing for you to know, regardless of which direction that contract clause is pointing. If that is a contractual provision that's running in your favor and you are relying on that provision in California, you better know now that that contract, that clause in that contract is void. Conversely, if you are presented with a contract and asked to sign it, and it contains an indemnification clause which makes you responsible for whatever it is that your customer does wrong, it may give you some solace to know, you know what, those aren't valuable in California. They're not valid. They don't count. And maybe that would ease your mind in regards to signing that contract. This, for Type 1 contracts, many other states bar their applicability in construction contracts, New York, Florida, Missouri, Colorado. However, to give you an idea of how complicated this situation is, in California, if you enter into a Type 2 contract, where you indemnify your customer only where you are partially at fault as well, those are allowed in California. California likes those in construction contracts. The difference between Type 1 is when the customer, the other guy, is solely at fault. In California, a Type 2 is when the other guy's a little bit at fault and you're a little bit at fault in some proportion. Those are perfectly allowable. However, they are not allowed in other states. New York, Florida, Colorado doesn't like those. Let's make it more complicated. In California, we have a Type 3 contract. In Type 3 contract is where you indemnify your customer only for your own fault. In other words, you go to the customer and say, look, we're not going to be responsible for anything you don't do wrong or anything a third party does wrong, but if we do something wrong, and by some manner you become responsible for it, we'll take responsibility for that. We will indemnify you for that. In California, that's perfectly allowable. Matter of fact, that's allowable in all states. That's what most courts look at and say, that is just fundamentally fair. More on indemnification contracts. Oddball rules. Many states have oddball rules, rules that are what lawyers call traps for the unwary. For example, in some states, the clause in the contract that deals with indemnification has to be in capital letters. If you write a clause, it's a brilliant clause. It's clear and unambiguous. It's fair. It adheres to the law in every possible way, but you don't use capital letters, it's not valid. In other states, the indemnification clause has to go immediately above the signature on the contract. If you put it as the paragraph second from the signature or third from the signature, or you put it at the beginning of the contract, even if you put it in capital letters and turn it into bright red, it's not a valid contract. I'm sorry. It might be a valid contract, but it's not a valid clause. That clause is not valid. In California, another example of oddball rules. In California, if you are going to enforce a contract against a customer whose employee has been injured, that contract has to have the signatures of both parties. Imagine this circumstance. You are an equipment rental house. You rent a forklift to a particular customer, a good customer. And the customer comes in and uses your regular form, signs the regular form, hands it back to you, and you hand them the keys to the forklift. Once that forklift gets back to site, the customer hands the keys and the forklift to its employee, and that employee subsequently gets injured. Later on, that employee sues you, claiming perhaps the machine was defective, sues you perhaps because you didn't provide appropriate warnings or decals, or perhaps because you didn't familiarize him with how to operate the machine. So it's a lawsuit from your customer's employee directed to you. You look at your contract. You've got a contract. It's a wonderful contract. Everything is in place. It's signed by the customer, and it's got an indemnification provision that runs in your favor. So you go to your customer and you knock on his door and say, you know what, I've got a contract right here. My lawyer looked at it, says it's completely valid. You are required to indemnify us, to make us whole, to defend us in regards to a lawsuit brought against us by your employee. In California, that contract is not valid unless you signed it too. Both parties to the contract, you and your customer, have to sign that. In the United States, equipment is rented across the nation constantly. Usually, if the contract is signed only by the customer. But in California, that's not good enough. You've got to have that contract signed both by the customer and by you before the accident. Now, what's our point here? Our point is not that you should go home and keep all of these oddball rules in your head. Our point is that there are big differences between states, that the language must be clear and unambiguous, and this is the most important thing. When you're looking at these contracts, get help from your lawyer or your insurance agent. And quite frankly, don't anybody tell my friends at the bar this, but the best help is really going to come from your insurance agent, because your insurance agent is the one who's insuring you, is going to insure you if you get into trouble. They don't want you signing contracts that give you an obligation to indemnify the other side in inappropriate circumstances. So your insurance agent, if he or she is worth his or her salt, should know this area inside and out And if you call them up, you say, I'm in this state, I've been asked to sign this contract with this language, and these many people are going to sign it, and the contract clause that we're talking about is at the bottom, but it's not in capital letters, and all that kind of stuff, your insurance agent should help you sort that out. A good insurance agent will be right on top of this issue. Next, the insurance clause. Lots of times, the indemnification clause is problematic. It's very complicated. It's hard to understand. And in a lot of ways, an insurance clause solves that problem. Insurance clause is very simple. It is a clause where one party agrees to buy insurance for another party. Or even more specifically, it's where party one agrees to bring party two onto its insurance policy, to call party two what we call an additional insured. The big advantage is that it avoids the complication and uncertainty of the indemnification clause. You send all that uncertainty away, all that complication away, and you just name the other guy as an additional insured, and that means your insurance is his insurance. But there's still problems. Be careful. You have to know what you're actually giving to your customer. If you grant your customer additional insured status, you need to know what you're giving them. Unless you can absolutely avoid it, try to avoid agreeing to provide insurance for situations where you are taking care of, you are providing the insurance for your customer's sole negligence. If you sign that contract and you say, I'm going to be responsible for you no matter what you do, even if I'm blameless, I'm going to provide you coverage for that, and you take that to your insurance agent, you're going to get a very unhappy case. And that the worst of that very will be your policy doesn't provide coverage for that type of thing. And that means if your customer does get into trouble, they have asked you to make them whole through your own assets. That's never a good situation. And if you don't, they sue you for breach of contract for failing to provide additional appropriate insurance. Try to avoid agreeing to provide insurance for incidents outside of your scope of work. You would be surprised how many times I see that in a proposed contract. A contract will come back with a clause that says you'll provide insurance for everything that goes on to the job site, even if you've left the job site, even if you had nothing to do with it, even if it wasn't within your scope, even if it wasn't anything that you had to do, you've agreed to insure the entire thing. Here are the important parts about this little talk. First of all, in the contracts that you're asked to sign, the insurance clause and the indemnification clause can be of extreme importance, almost as important as that other important thing, which is how much are you going to get paid for this contract. Both of these areas are extremely complicated, very difficult to find through, and they change from state to state to state. As you are evaluating insurance clause and indemnification clauses, be sure to get good advice from your lawyer or your insurance agent. If you have any questions about this, I'd of course would welcome a call. On the screen you can see my email address, tpeterson, Peterson has an S-O-N in it, at behblaw.com, and my phone number is 415-403-4482. I hope you found this interesting, and probably even more important than that, I hope you found this to be useful. Thanks so much.